Thank you very much, Ms. Harpreet. It is our proud privilege to welcome Professor Upendra Baxi in this webinar. And Professor Upendra Baxi is a doyen of Indian legal education. And today's topic is on constitutional morality, that is Cataclysm, Conundrum, or Catastrophe. He is multidimensional, and Professor Baxi has been kind enough to pick up this topic, which is very uh, news. Many people have different views on this. If you see our present Attorney General, he has a different view, which he feels is a very dangerous thing, which Apex Court sometimes indulges under Article 142, that is to do complete justice. And if I can quote him, once he has told that constitutional morality can be very dangerous, and he fears that Supreme Court may become third Parliament chamber. This he told in a seminar. And I like to quote one more case to highlight the importance of today's webinar. And the Honorable Apex Court in Indian Young Lawyers Association versus the State of Kerala in 2018 held that Rule 3B of the Kerala Hindu Places of Public Worship Act, which validates customary practice of prohibiting women of certain age to enter inside the Sabrimala, is manifestly arbitrary. And in the same bench, the lady judge, Honorable Ms. Justice Indu, the very contrary view. So many people say that the constitutional morality is a very dicey thing, which can lead to a lot of confusion and uncertainty. And today, our most respected Professor Upendra Baxi will clarify many of our doubts which we have. And then we can also ask some relevant question and the end is a webinar. So I'll say a few words about Professor Upendra Baxi. He has been very kind enough and he is showering his affection to all of us, legal fraternity. And we, School of Law, Sharda University, have been beneficiary of his legacy. He has gifted some of his very rare manuscripts, close to 900, 950 books. And his students and faculty are greatly benefited by that. And we hold you, sir, in very high respect. And we are sure that we will not leave any stone unturned to ensure that our residents, they are becoming the brand ambassadors, and they bring justice, they bring liberty, they ensure dignity of the individual. They don't only lawyers in the technical meaning, but they bring a lot of reform on the ground level. And sir, I like to tell that our residents are helping a lot in administration during this COVID-19 situation. And we have been, a lot of domestic violence cases are coming up in this lockdown situation. And our School of Law is partnering with administration. And every week, our faculty with doctors, with psychiatrists, with clinical counselor, they take out their time. Whole day we counsel the families, we save them from the court cases, from the police cases. So in this way, we are doing our bit and we are helping a lot of families. So with these words, sir, I will once again, on behalf of the management, on behalf of Professor P.K. Malhotra, he is our guide, friend and philosopher. And on behalf of our learned faculty, dear students and my dear participants, once again extend a very warm welcome to you. And we are privileged to have your precious time. Thank you very much, sir.
Thank you, Dean Sir. I now request Mr. P.K. Malhotra, former Law Secretary, Union Ministry of Law and Justice, and a very distinguished professor of School of Law, Sharda University, to share his thoughts on the topic. Sir.
Thank you very much, Professor Upendra Baxi, my teacher, my guide, my mentor, Professor Pradeep, dear faculty members, other distinguished participants, and my dear students who are all participating in this webinar. Sharda University always try to keep in touch with the students, not only in the classroom, but in other areas also, as Professor Pradeep was just sharing, that we keep on doing other activities, holding moot court, both Parliament and the Legal Aid Clinic, and now the Family Court Dispute Resolution Center, which the Ghaziabad police, Noida police has started, and Shardha University is cooperating in a big way. Professor Bakshi's today's topic, which he is going to speak, I think all of us are interested, and it is very, very relevant from today's point of view. More particularly, before the start of this webinar, I just was having a word with him, and what he said was that it is a hot topic. And my observation was it is not only hot topic, it is too hot a topic, because the way Supreme Court is coming out with various directions which are being given under Article 142, or the use of public interest litigation in many matters, has raised this issue of constitutional morality, and more particularly with reference to Cataclysm, Conundrum, and Catastrophe. If we have to here, I think we could not have thought of a better person than Professor Bakshi to deal with this topic and enlighten us on this particular subject, because this is a basic topic which all of us as students of law must understand if we really want to serve the society in accordance with the goal which are enshrined in the Constitution. Now, just as an introductory remark, let me say a few words that the term constitutional morality, when we are talking about, is not used in the Constitution. But yes, word morality does find place at various places, including in the chapter relating to fundamental rights. More particularly, I think Article 19, maybe Article 21, Article 25, Article 26. And even the Supreme Court, while giving various judgments, has not clearly defined the term constitutional morality, and therefore it leaves the scope for its subjective interpretation by the individual judges, and this is what is happening. And probably it cannot be defined or fine-tuned in the way, because circumstances in each case may differ, and within the framework created by the Constitution, probably it needs to be interpreted what constitutional morality means. And if in the general terms I have to say, what I will say is that it is, it in fact means an effective coordination between conflicting interests of different people and the administrative cooperation to resolve them amicably by all the three organs of the government. And when the two organs fail, the judiciary steps in and it has to play a large role. And if you are talking, when I'm talking about the constitutional morality, it is largely covered under the chapter relating to fundamental rights, the directive principle of state policy, the fundamental duties chapter which was added later on, and of course the preamble of the Constitution. The principles of constitutional morality which have been interpreted from time to time, if I have to quote only few judgments which are immediately coming to my mind, of course Professor Bakshi will be dealing with it in greater detail. Of course, Keshwananda Bhakti can be one of them. The recent Sabrimala judgment can be one of them. The Nas Foundation case can be one of them. Or the rights of the LGBT community can also be one of them. And more particularly, the wide interpretation given to Article 14 and Article 21 of the Constitution, I think is another area where Supreme Court has evoked constitutional morality and applied it while giving its judgment and decision. Many times it is felt that in case the constitutional morality is applied by the judiciary, probably it amounts to judicial overreach. Does it really amount to judicial overreach in all cases? I think is a very, very pertinent question, and all of us are willing to hear the views of Professor Bakshi on this particular issue. Sir, we welcome you to this webinar. I think the participants are not only our students, there are many professors, teachers, other legal practitioners, as well as teachers from other universities also who are participating in this webinar and are looking for your words of wisdom and guidance on this particular topic. Thank you very much. Over to you.
Please welcome Professor Baxi. Sir, please. So you will have to unmute yourself. So you will have to unmute yourself. We cannot hear you.
Can you hear me now?
Yes, sir.
Yes.
Okay. Well, welcome to this conversation. And I feel extremely privileged to address such a distinguished body of teachers, researchers, students, and principals and deans and all kinds of colleagues who are present today. First of all, let me wish you greetings on the Eid festival. Eid al-Adha. It's our duty as citizens to preserve the composite culture of India. This duty is enshrined in Article 51A. I'll come to that in a minute when I discuss the subject. But greetings for the occasion to all of us. Special thanks to Dr. Pradeep Porshastra, who has been a very good friend, and all of you in the Sarda University, where, as the advertisement goes, the world is here, where are you? And that question, where are you, is so powerful that even I have kind of joined Sarda University. Prem Malhotra, of course, has joined as a professor, but I dabble from time to time into your affairs, and I'm very pleased to be here. I'm not very sure about the format of the discussion, but I hope there will be a lively discussion as soon as I finish, and I have only 5 or 6 points to make. So first of all, I also thank Professor Malhotra for very gracious remarks, very valuable remarks, but also some provocations, some puzzles at the outset. And that's what I mean by constitutional morality as a conundrum. Everybody has views on morality, and some have different views than others. And therefore, there is always a search for a common meaning of the expression. This goes also for basic structure. This goes also for reasonableness. This goes for purposive interpretation. So what Malhotra has raised a wider question, whether standards can be made into rules. Standards are like reasonable person in tort law, are more general forms of law. Whether standards can be converted into if-then proposition, which a rule is. We act in a certain way, then certain consequences follow. And it's a very big debate. We would just sound it. I don't think we can go into it. I'm very glad that that Dean Pradeep Porshastra has talked about the outreach in COVID times of his university. I'm very glad that you're doing such wonderful work, and I hope you keep on doing that, and you surely count among the COVID warriors. Each one of us has a difficult time ahead and a difficult time in the distant past. And I wish all of us extremely well in fighting this sinister global pandemic. Now, my first point is a more general one before I come to constitutional morality. And to save time, I would say CM. Constitutional morality is CM. So when I say CM, I mean constitutional morality. When we talk of CM, we can talk as outsiders. to India, and we can talk as insiders to India. Insofar as we are all citizens of India, we are bound by the Constitution of India. I wonder whether a constitution can be without a morality of its own. So it is a puzzle to me that some people object to the idea of CM. But my first point is about constitutional duties. What is the difference between a citizen and a subject? It's obvious that a subject is a being or a creature without rights, but a citizen is a being with rights. Or one can go back to the old Aristotle, some 2000 plus years ago, and he said a citizen is a being who knows two things well, and only then she is a citizen. In his times, people only refer to he. The word consisted of he, but we now know that it does not consist of he. It consists of she and it also, the trans people. So, thanks to the constitutional morality again, it comes in directly. So, it is, Aristotle said, two things have to be satisfied. A citizen must know how to rule. A citizen is a person who knows how to be ruled. Because those who rule us are also citizens. So they must know how to rule, and people must know how to be ruled. The old ancient Hindu concept of Raja Dharma says very much the same thing as good old Aristotle said. So I think a citizen with rights, I think our Constitution says in Part 3, a citizen has certain rights, as we all know. And there is also Part 4 citizens, with citizens who have rights but who are still rightless. A paradox of rights going with not having rights at the same time. There are Part 4 citizens and there are Part 4A citizens. Short paragraph in the Constitution, added in 1975 in emergency, which has not been amended away, but amended further to include more duties, and which has been interpreted by the Supreme Court at least in 2 or 3 decisions. What are the duties of citizens when you think of CM? And I think one duty that comes to my mind is the duty to develop scientific temper, spirit of inquiry, and reform. And there was a critical spirit towards the existing situation and institutions. The second important duty, and I don't go through 11 duties that are fundamental, I go to 2. Second one is a duty to develop excellence in all walks of life, individually and collectively. What is the enemy of excellence, I ask? Everybody should ask that. And everybody, there's only one answer. There are very few questions to which there is one answer in life. This is a question which has one answer alone in life. What is that? The enemy, according to me at least, of excellence is mediocrity. So it's the only constitution which forbids mediocrity. And this is implication on developing the concept of constitutional law. And it is in that spirit that I speak today of CM. My second point is about cataclysm. Some people regard it as cataclysm, CM as cataclysm. I think that's an extreme view. That's a view which says a violent social upheaval, which is a view that is the literal meaning of cataclysm. I don't think any constitutional concept is a cataclysm in that sense, it's a disaster in that sense. You might disagree, you might nuance it, but we cannot say it's a cataclysm. Okay, it's not violent, it's normative. And the one feature of norms is non-violence. Enter into a discussion on the standards that one should follow. So it's obviously a non-violent affair of interpretation. And therefore, I mention the word cataclysm because some of the colleagues view, for example, basic structure and CM and many other things, as Prem Malhotra said, as probably the outrages anyway as being examples of judicial overreach. I don't think this CM is cataclysmic, but you're welcome to discuss that in discussion to follow. So I explore the idea of CM being a conundrum or CM being a obstacle to development or CM being something else. What is conundrum? That's my third point. A conundrum simply means, I think, that something has multiple meanings, as Prem, no doubt, and Pradeep also said. It has multiple meanings. My question is, what in constitutional law does not have multiple meanings? Everything has multiple meanings. In fact, if there are no multiple meanings, you won't require two sides to argue for long as to the meaning of the words. The lawyers make meanings with judges. It is never a solo affair. It's never an affair of a judge imposing a meaning. It's a joint production. So I do not think multiple meanings as such is a problem. But of course, we must have some certainty in law, to which I'll come. So let us look at the multiple meanings of CM. One meaning, of course, today we are all experts in Greek history. I don't know how, but there's a man called Croce, who wrote about history of the Greek in the world. And he's referred to constitutional morality, to which Babasaheb Ambedkar also referred in Constitute Assembly debates, and to which Prof. Bhanu Mehta also referred to in article in seminar. And we are experts in shortcuts, so we now think we know what Croce said. Croce said. I don't wish to go into what Croce said or what could he have meant, nor the gloss of Ambedkar on Croce, nor a further gloss by Pratap Bhanu Mehta. But I want to take one idea from him, and that is, it's a sentiment. CM is a sentiment. It is not natural. It has to be cultivated. And they have to be cultivated by the Constitution. This refers to a slow growth of a popular sentiment. That is one meaning that is given to the idea of CM. And Ambedkar very rightly spoke about democracy being topsoil of the Constitution. Underneath is inequality, whether of gender or caste or whatever. So, rightlessness of human beings. The second meaning, and I'll be very quick, is the widest meaning. It is given by Professor Sathe, Professor Andre Betty, and others. And it says, well, let us try to measure whether the constitutional goals have been fulfilled. And one way to find out whether the goals have been fulfilled or not is to recourse to CM. whether constitutional morality has been observed by all the wings of the state. Take corruption, for example. Take women, for example. Take untouchables, for example. Take any number of examples. Take disabled, for example. Take mentally ill, for example. And obviously, you can say that same has not been achieved. So there is a morality is the troublesome word in CM. One is, as Professor Longfellow said, the morality of duty. The second is the morality of aspiration. Now, critics don't make it clear whether they are talking of morality of duty or morality of aspiration. Prem Malhotra referred to the preamble. Now, some people would say preamble exemplifies the morality of aspiration. Some other people will say, no, it embodies the morality of duty. I myself say that the preamble to the Constitution is one voluminous footnote to the Constitution itself. Without preamble, Constitution does not make any sense. So there are different views. And it's very difficult to judge an institution like the Supreme Court or Supreme Court and High Court, like legislature, like Parliament, over 7 decades as having failed or succeeded. That's a mammoth task of judgment and description. You have heard, I'm sure, of Mohammed Rafi's song, Ek dil ka tukra hajar hua, koi yahan gira, koi wahan gira. This is what happens when you judge 70 years of experience. You never know which side the piece fell. Some successes, some goals, some failures. So you have to balance them, you have to come to a judgment. But this is the second meaning. It's a wider political and sociological meaning of Constitution. The third meaning is more limited. It says the lawyer-like meaning. Let us find out where the Constitution refers to this term morality. And Surabhi Shukla, who is a doctoral student at Oxford, is working on a PhD on this very subject. And she found 4 places where the Constitution explicitly speaks of morality. For example, Article 25, which restricts religion on the ground of morality. So I won't go into the other 3 instances, but she gives 4 instances. That's an extremely focused meaning, perhaps even narrow, perhaps too legalistic, but that's looking at the text of the Constitution. The fourth meaning is what Upendra Baxi, in his weaker movement, adopts. What is that meaning? It is the meaning that refers to, it says, CM is the large of the Constitution. It is everywhere. It is not here specifically or there specifically. It's everywhere. That's the meaning of writ large. And it is writ large on judicial interpretation. So this view is we'll come to this view in course of point 4 and 5. There are some friends of mine who don't like the idea of CM. I don't think Prem Malhotra goes that far, but he also thinks, and probably Dean also thinks, well, it's a bit too much of judicial interference. Well, maybe. But I refer primarily to Attorney General, my friend Venugopal, views on in his J.B. Dalachandji lecture. Dalachandji was a great lawyer, a great legal firm that he set up. Jimmy was a good friend of ours, and he received many students of mine to table with him. And second friend is no more, Madhav Menon, and Madhav wrote an article saying 8 burning questions on CM. He got the burning questions, I'm sure, from television program, entitled Burning Questions. And I replied to him. Essentially, their argument is as follows. First, it violates SOP. Do you know what SOP is? SOP is separation of powers. SOP is, it may come to you as a news, is not embodied in our constitution. But it is there in our constitutional rhetoric. From 1953 or 54 judgment of Ramjabhai Kapoor versus the state of Punjab, to Keshwanda Bharti in 73, and lots of other decisions. The Supreme Court has constantly said, our constitution does not know the word is important. Every word in law is important. Strict separation of powers. Strict separation of powers. What is the strict separation of powers? Nobody's asked this question, but I read the judgment. I have the bad habit of reading judgments and thinking about them. I've read them. And I think that is first view. Secondly, they argue that CM is dangerous for democracy and rule of law. Separation of power is judicial overreach. The second argument is it is outright wrong. The third argument is it is subjected to too many judicial interpretations, or vagaries of interpretation, as Prem said a moment ago. I have disagreed in writing, and I disagree today with this denunciation, with this diagnosis, and the prescription that follows. Then we should get rid of both the doctrine of basic structure and the doctrine of CM. We can't get rid of it, but if we were able to get rid of it, that is, if we can get rid ultimately of interpretative independence of judiciary. I don't think you can get rid of it. But you can discipline it, you can tame it, but you cannot get rid of it wholly. And that is proved by the second case during the emergency. The first case during the emergency, everybody knows, Sivkant Shukla habeas corpus case. The second case occurred in 3 months' time of habeas corpus case. And that's called Indira Gandhi versus Radhanarayan. What happened there? I can't go into all the details, but shortly put, the court struck down the 39th Amendment in the height of emergency and said basic structure rules, and it violates the basic structure. Article 39 put all the proceedings against the Prime Minister in as null and void, and struck down any suits pending against the Prime Minister, President of India, Speaker of the House, this were all the four mentioned, struck them down from the judicial roster. And the judges said, ma'am, you can't do this. And they said it in the third month of Indian emergency. Nobody has noticed this case. And surprising part of that is the very same judges who deferred in Keshwanda Bharti in 73, like Justice Chandrachud, Senior, led the opinion in Keshwanda and in Radhan case, in which he critiqued, he had earlier critiqued the idea of basic structure, but in which he applied basic structure. And in which Justice Khanna made an important addendum and retrospective dissent from his own opinion and included secularism in basic structure. So we've not read. So I say this is absolutely no way in the world to get rid of this concept of basic structure. And if you study closely, the expression CM appears in Keshwanda Bharti a large number of times and to be enumerated upon by many justices. in Keshwar. So, my seventh point. My sixth point, I'll end by saying, there is creative uncertainty in interpretation of CM. But is that a good ground to say it should be junked? There is creative uncertainty about many concepts. That's why the Supreme Court is there to settle this creative uncertainty for the time being. More uncertainties arise and to settle them again. This is a dynamic part of judicial process. Now, how can one eliminate it in judicial, in democratic constitutionalism? It's a million-dollar question. Now, my last point, and then I'm done. What does creative uncertainty imply? To my mind, it implies conflict of rights. The rights are in conflict, and these are fundamental rights in conflict. In Sabrimala, which was referred to by Dee, and our discourse will refer to, I'm sure, there was no dissent at all on the issue of CM. Even Justice Indu Malhotra agreed with the idea of CM. Most critics have not read the judgment. Dee, forgive me. If you read the judgment carefully, Justice Indu Malhotra has never said that constitutional morality is a bad constitutional concept. In fact, she agrees with it. Her difficulty lies elsewhere. That is, what do we do with what she calls pre-constitutional morality? So there's a conflict between what I call CM and PM1, pre-constitutional morality. When CM, by definition, did not exist, what existed in national freedom struggle was PM. When I use the word CM and PM, I don't mean to give you a political speech. I'm not concerned with that sense of CM and PM. I'm talking of abbreviations in the discourse here. So Justice Malhotra did not disagree. If they agreed, she disagreed on application of constitutional morality to this case by asking whether PIL, so-called public interest litigation, was a sensible way of deciding my religious freedom, on which people can differ. Then there is the PM2, which is called public morality. PM2 is not Vivekananda and Aurobindo and people like that before the Constitution. PM2 is after the Constitution. From Naz to Navte Johar, by Kaushal, of course. As you know, this Supreme Court has held that PM2 is always subject to CM. In real life, the CM is subject to PM. That's a different discourse, as I said earlier. But in the field of constitutional morality, the CM overrides PM2. And it may override PM1, because PM1 might be misogynist, might be sexist, might discriminate against gay and other sexual minorities, might be repressive to untouchables. Even the Article 17 constitutes constitutional morality. And it said practice of untouchability is thereby abolished. Which constitution of the world abolishes as a penal offense what is there in Article 17, Article 23 and 24. So that's a point that is to be pondered over. So therefore, the question is not of conflict of rights. It will always exist. question is of negotiation of conflicting rights. And the question is of wise negotiation of conflicting rights. And it's not a question that will be settled forever. It can be a question that can be settled for the time being. In different generations, different contexts. For example, soon after Sabrimala was decided, there was a case in Madhya Pradesh where Digambar Jain case, Mandir Temple case, 2 months after Sabrimala was decided, the question arose, whether Sabrimala applies to a situation of Digambar Jain, where they could watch, women can watch every part of the statute, but not certain parts. Abhishek, they can't perform in certain parts, but otherwise they can. Whether Sabrimala applied, the court went to find distinction and said Sabrimala does not apply. There's no discrimination against women. Hardly anybody has studied cases that happened after Sabrimala and how the judgments were interpreted about religious violence. So in the end, what I want to say is this. CM is not a monopoly of wisdom by the Supreme Court of India. You can have CM as practiced by Parliament of India, and you can have CM as practiced by the Executive of India. But the control point is to be assumed by the Supreme Court of India. Whether it's a purpose of interpretation of the Constitution, whether it offends the basic structure, whether it offends other rights given in Part 3, is all a matter for Supreme Court to decide. Therefore, I would suggest that CM is an interpretive concept. And this phrase is used by Professor Ronald Dworkin and is elaborated. And I think interpretive concepts are concepts that help interpretation by the judges. CM is one of those. It is embedded in the Constitution and it can be diversely interpreted. It has been by judges themselves. But that is not a good enough reason. In fact, that is no reason at all to dismiss the concept as a judicial overreach or things like that. I think I'll end here, Pradeep, for the time being, and collect your questions. And if possible, respond to them.
Thank you very much, sir. By the time we have participants ready with their question, if you allow, I'll like to raise one small clarification.
Yeah, please.
Sir, you have observed that the control point of interpretation of CM should be with the judiciary. If I have got you right, sir.
Yeah.
But sir, the Constitutional Assembly, while discussing procedure established by law on 6 December 1948, they held that we in a democracy we should allow people's will to prevail, not will of judges to prevail, and they didn't go with the due process of law.
Yeah.
So here,
one now or collect?
Yes, sir.
Yeah, the will of the people if you think carefully, will of which people? Representation is a very difficult concept. For example, anyone below 18 is not eligible to vote, I think. How is representation constituted? Prisoners are not allowed to vote in India. I don't know whether I don't remember whether it applies to under trials also. Probably yes. I don't know. I've not done empirical study. You should probably commission such a study, but under trials can. You don't have to have any connection with the state. You don't have to own property, you don't have to have studied there, you don't have to have family there in order to represent them in the Council of States, Rajya Sabha. There's a famous judgment of the Supreme Court. Supreme Court itself has held that there is no linkage required. It was a judgment in what Piyush Sale or somebody raised it. Supreme Court said you need not be connected at all with the state whom you claim to represent. So I'm not saying that there is no such thing as will of the people. Of course there is. And of course, one can say Parliament is entitled to express the will of the people. But judiciary also, in social extra litigation elsewhere, against black money, right? Many such cases, Supreme Court has expressed its faith and trust in the people of India. And it says our judicial review powers are based on the faith and trust of the people of India, which they repose in us. That the final justification of judicial review is people's faith in us, in a non-representative institution. So I'm saying, all I'm saying is, you're right. All I'm saying is that representation is performed in diverse ways. NGOs claim to represent people. Corporations claim to represent people. Scientists claim to represent people. Political actors claim to represent people. Supreme Court, High Courts claim to represent people. There are different ways of representation. So we have to examine this whole matter of will of the people is important, but it's not only representative institutions. I used to say, I don't know what the position after NEP, but I used to say that in universities, we are paid to make simple things complex and complex things more complex. Huh? So I don't know what the position now. I don't deal with things. But will of the people is a complex concept. There are also non-representative agencies which can claim to represent them. They're right or wrong is a different matter in a particular context. Because in Maneka Gandhi onwards, the Supreme Court said it represents the will of the people. The will of the people is that there should be no manifest arbitrariness in exercise of public power. That public power should be held as a sacred trust on behalf of the people. That too, resources held by the state are not resources for political profligacy, but resources that are due to be used in the service of the people, the dietary principles of state policy. Were they expressing will of the people or not? I don't know. Very important question that you raised.
Thank you very much, sir. Ms. Harpreet, you can take few questions with the permission of Honorable Baxi, sir.
Yeah.
So there is a question which is asking, what are your views on constitutional moral conflict between freedom of speech under Article 19 and contempt of court, giving fair criticism in the light of recent contempt case against Advocate Prashant Bhushan?
I didn't get the second half, but insofar as freedom of speech contributed freedom of speech and CM is concerned. That part I understand. The power to lay down reasonable restrictions were vested in Parliament under 1902. Supreme Court, by interpreting the reasonableness or otherwise of that restriction, can also and does very frequently legislate CM. Now, if you have read the Civil Rights Protection Act, which is meant for untouchables, Section 2 or 3 of that Act clearly says that any exercise which justifies untouchability on historical, political, or social ground is an offense. It's a restriction on freedom of speech. Here, the constitutional morality will tell you that's a justifiable restriction. The Article 17 requires and it defines, says, and also the only constitution to say this, that practice of untouchability under any ground is an offense. And Article 35 of the Constitution says Parliament shall pass a law creating an offense. 35 is a part of fundamental rights, part 3. And it says, it overrides the whole scheme of federalism. It says, regardless whether the state has power or not, Parliament shall make law as soon as possible in relation to Article 23 and 24. And 23, 24, 17. For 3 provisions: bonded labor, child labor, and untouchability. So, very often, CM is very often. What happened in Navtej Johar? In Navtej Johar, the Central Government Union of India, what did it argue? It did not oppose. It said, we leave the decision to the wisdom of the Supreme Court. So technically the judgment is based on the what law is called concession. Right? But the judgment proceeds to give full rights of privacy and dignity to LGBTISQ people. And quite rightly so. So very often you find an agreement on CM as applied by the Supreme Court and the executive. Very often the executive wants it. So I'm staying away, you might think I'm staying away from your question, but I probably am not. I'm saying nothing is set in stone. Everything is is imbued with purposive interpretation. Purposive interpretation is practiced by executive, by legislature, and by judges. And in some cases, in cooperation. In some cases, in conflict. And ultimately, the conflict of rights is settled in the Supreme Court. The question underlying that question, of course, and I won't take much time on this, but it's a very important one. Namely, whether you can say that a Supreme Court judgment is non-est, invalid, does not exist, because in your opinion it violates fundamental rights. That's a very deep question. Can the Supreme Court ever violate fundamental rights by interpretation? And that requires a lot of research. So there are some judgments of the Supreme Court. Naresh Miraskar is one such judgment, where some judges say, yes, Supreme Court can violate certain rights. But there's nothing beyond the Supreme Court. And there's Article 141, which says the law laid down by the Supreme Court. So it's an important question in that sense. What if you decide to say that Supreme Court has violated freedom of speech? What do you do? That's a good, very important question. I don't know how Mohandas Gandhi would have answered this question.
So there's another question by Subir Bhatnagar. Uh, do constitutionalism and CM overlap? Out of constitutionalism and CM, which one is broader?
Sir, Professor Bhatnagar is Vice Chancellor of RML National University, Lucknow, and we are obliged that he has joined in this webinars.
I'm also very glad to welcome Professor Bhatnagar with you, but I didn't get the second half of the question.
So the second half is out of constitutionalism and CM, which one is a broader concept?
CM, oh, very interesting question. I think it depends on what you mean, what to mean by constitutionalism. Now, I have a initial classification which I made in Cardozo's Law Review article between C1, C2, and C3. C1 was constitutional text, C2 was constitutional law, and C3 was theory or ideology of the Constitution. Then in 2012, I changed my views. I said, you can't have only three categories. You should have C1, C2 will decompose into 12 further categories. C2 cannot only be interpretation given by courts. Constitutionalism is interpretation given by the executive, by the legislature, by parliament, by state legislatures, by army, armed forces, by corporations, by a number of people. And above all, citizen interpretation. It's not law, but it is about to be law. It is law in the end December. For example, you can't understand constitutionalism in America without understanding Martin Luther King Jr.'s fight for equal voting rights in Alabama. It took a long time for Equal Rights Act to come into existence. You can't understand a constitutional development of women in the army. It took 70 years to get commissioned officers who would fight on the frontier. Again, the Supreme Court, two-judge bench, and the government took that into consideration. So in a sense, there was a time when the Supreme Court itself said that women cannot be allowed to fight and perish. They don't have the capacity, they should not be given the status of combatants. They can do the non-combatant job. But that CM was changed 180 degrees in favor of women by recent judgment of Justice Chandrachud and Rastogi, Justice Rastogi, as you know. So, if you are thinking of how to bring changes in constitutionalism as ideology of the Constitution through CM, then you have to study the way in which CM is being argued and CM itself changes. If you look at the pre-constitutional morality, there's room for saying, if you look at Karachi resolution and others, that women are equal to men. There should be no discrimination. That was one of the planks of the freedom struggle. Something came in between which is quite different. And now constitutional morality is applied now by the courts, now there is other places, to bring in changes in constitutionalism. So constitutionalism also has to be understood as from the standpoint of C1, that is constitutional text. Constitutional text changes only when Government of India press prints the changes. If you look at the Constitution of India today, no mention of the Supreme Court judgments is to be found. Even today, Article 21 says procedures are established by law. Although the Supreme Court has said different things. So it is habit. But C1, that is, C1 refers to changes in constitutional text. That's the function of Article 368 in Parliament. Changes of constitutionalism have nothing to do with the text, like the NJSC judgment, number of others, like adultery, like any number of cases. They come by judicial exertions of judicial will and exertion of people's will, NGOs and others. Therefore, changes of constitutionalism, changes in the text of the Constitution, changes of constitutional norms, ideologies occur by C1 differently. But I promise to think some more.
So there are some questions on the same lines. Should I state them together for you to answer them collectively?
I think so. I think so. I take a note down, and you correct me if I overlook somebody.
Sure, sir.
Yeah.
So one is, how do we distinguish between public morality 2 from CM? When CM exists at all points of time, does it reflect PM2? Then, sir, another question is, do you perceive any relation from CM with basic structure?
Yeah.
Then, sir, is it fair to interpret CM in the context of PM of foreign countries?
CM of?
CM in the context of PM of foreign countries.
Oh. But
So then there's another question.
yeah, I take one
Judgment
more.
based, okay, sir.
Yeah, one more, and I take. But if I may take three for the time being.
Okay,
Very,
sir.
very simply, CM and overseas, the third question, overseas comparative jurisprudence. If you look at NAS, the judgment of the High Court, it refers extensively to UN Convention, to sexual minority law being changed, constitutions being changed, changes in the offing. So, of course, constitutional morality is not always universal, but there are some instances where most societies converge into a particular notion of equality, women's equality, or the most widely ratified convention that United Nations has ever, and the most radical convention in the world history, is Convention Against Elimination of All Forms of Discrimination Against Women, CEDAW. Now, that's a massive consensus. So very often, yes, you have to look, you can look, if you want, at constitutional morality as it operates globally, universally. Like in capital punishment, a gradual abolition is required by ICPR, but a lot of water has flown in the bridge, and it is now the second covenant of the ICPR covenant, and so on. Protocol. So there is a lot to be done. But it does not ultimately, one is applying, there are some differences, because there are some states, like Anglican countries or Islamic countries, don't agree with certain human rights norms. And therefore, when you appeal to comparative jurisprudence and a universal ethic, there are only a few norms on which there is complete agreement. There's a number of norms in which there is incomplete agreement. There's agreement, but incomplete. And one has to distinguish these features. Or one can immerse oneself in one's local context and say yes or no. But certainly CM is higher than PM2. So ultimately the CM should prevail. Because CM is modern morality, which fights against discrimination, which calls for inclusion. Now, there are people who might say colonialism was a good thing, let us be colonists. There are people who might say, what is wrong with being colonized? What is wrong in giving women a second-class citizenship? What is wrong in reintroducing slavery? There are people. But is that view necessarily moral, ethical? Modern human rights say no. Now, some people argue against that. They say modern human rights are a moral mistake. That's what conservatives do worldwide. And we don't want any restraint on discrimination in social life. And that's, is it right or wrong? Let me discuss this view. On the question of CM and basic structure, I think I said it. If you look at Keshavanda Bharati, which elaborates the notion of basic structure and essential features, it is almost there in every judgment, every opinion in Keshavanda Bharati, one way or another. So they have relied on question. This is what I call moral reading of the Constitution, that Dawkins says. That you read the Constitution not only as law's document, not only as political institutional document, but as a document of ethics, of public morality, what it ought to be, a document elaborating the preamble's values of equality, justice, and liberty, and fraternity, and dignity. So it is possible to establish a very close connection between PM and BS. And PM2, I don't think I got the question all right. So when you come back to second round, now you can tell me again what you meant by PM2. I only got PM2 question mark.
Okay. So I'll read it out to you again.
Yeah. I finished.
So the second part is when CM exists at all points of time, does it not reflect PM2?
PM2 is post-constitutional public morality. PM1 is pre-constitutional public morality. So I don't see the question. In my opinion, CM certainly applies to PM2. That's the whole question of judicial renovation on purpose of interpretation. So I still don't see the question. I think it applies, it definitely applies. Public morality must run subservient to CM, constitutional morality. And it's not the case, it's never the case that judges act in blind disregard of public morality. But they would not allow public morality to discriminate against people on the ground of the color of their skin, their religion, their language or culture or status or any such thing, sex. The norm for anti-discrimination is at large on CM. That's the norm of fairness, that's the norm of liberty. No discrimination shall be allowed. Now, whether in this case or that case, that rule of the norm of non-discrimination conflicts with the rights of religious integrity, well, Hindu Malhotra, Justice Hindu Malhotra, beg your pardon, says that only a member of the denomination can bring an appeal about whether only a person who is member of that religious denomination can file an appeal, or an outsider to religion. And if you look at Justice Kair's and Justice Nazir's opinion in Sadia Banu case, they say there is no discrimination against anybody. In the question of personal law is sacred, they say. You should not allow Parliament or the state to come in. And they've gone to town, they've gone a long judgment, good reason, saying why constitutional morality does not apply. And that's why Sadia Banu is a complex judgment. It's a judgment in which two judges take the view that personal law is beyond the bounds of the Constitution. Roughly. So sometimes real conflict, because why do they say so? They say they're afraid, like Justice Subbarao was afraid very early on, of what is called statism. That you should not allow the state to have all the powers. And social reform must come from below, not from above. Right? So apart from cases where the Constitution shows considerable impatience, like Article 17, 23, 24, or 15, reservation, it shows impatience with injustice and wants to do something now, concretely. So it's different. Apart from those cases, some people take the view that CM should not override PM. And that's I would not say this a wholly unreasonable view. But from the point of view of victims of injustice or misfortune, the question is, for how long shall we continue to bear the burden of discrimination? Why should we be treated as equal to anybody else? And that's, I think, an issue that is raised only when you allow CM to be higher than PM2 or even PM1. If CM is to follow PM2 all the time, then there is no conflict. That's my thinking.
So there are many questions. Are you ready to take the next few questions?
Yeah, what is it?
Okay. Please enlighten us a little bit about the constitutionality of Ayodhya judgment and lifting of Article 370.
Article 370.
Yes, sir. Lifting of Article 370.
Oh, Kashmir. That's it. What is the question?
So they just want to know your opinion about the constitutionality of lifting of Article 370 and Ayodhya judgment.
What's the value of my opinion? India is a lovely country.
So constitutionality of these two judgments, if you can explain us, make us understand.
I know what you mean. I know what you mean. But the point is, it's a beautiful country and a beautiful system. You have a right, every citizen has a right to free speech and expression. But nobody is under duty to listen. From my opinion, it doesn't matter in the scheme of things. That's the preface. You might hold an opinion and you might say it is your opinion. But what is that opinion before? How is that opinion to be counted? I can only study the matter and give opinion. And when I study the matter, on repeal of Article 370, the matter is before the Supreme Court and its constitutionality. I do not know how the case is to be argued, when the case is to be argued, but it is before the court, Supreme Court. I've seen at least one writ in which the arguments are made, but my responses are not fully documented. So it's a long affair, and the court can decide either way on that repeal. My own view is that 370 was actually amended a number of times by the executive. So it is a common ground that 370 was almost amended away by the executive and legislature. But anyway, once Parliament has spoken and the matter is before the court, it is useless to collect individual opinions because they are not going to help matters in any case. But on curiosity, yes, I agree. Take Ayodhya, for example. I've written articles on Ayodhya. I'm in minority of one as far as scholars are concerned. I've been grossly misunderstood. But I've said, well, you had negotiations. Enormous number of initiatives were taken, including a court-directed negotiation. Every party said it is best left to courts. Court then expedited the hearing after 10 years and found that this was decided to treat it as property dispute. Nobody argued that it was not a property dispute. A property dispute has to be dealt with by a certain logic. And one of the rules in Transfer Property Act, Evidence Act, and so on, I don't want to go into details, is that the burden of proof lies on the person who alleges that a certain state of affairs existed. You have to prove it. For one reason or another, one party which alleged that there was a mosque, a prayer to offer, was not able to prove it. No? So, I've did a very elaborate judgment. I've read it several times. I've written on it. That it was not a constitutional dispute before the court. It's a property dispute. And the doctrine of adverse possession was applied. And no adverse possession was proved. Now you might, going through the evidence, take the other view, which was argued by Rajiv Dhawan and many others. It is a matter of appreciation of evidence. What did the court do is important. Court says twice the amount of that land will be given to the Muslim Waqf Board. If you give 2.5 acres, something, to Ram Lalla and Madhu, then we give 5 acres for a mosque. The court said the mosque should be situated in Ayodhya, and the government should take steps to give the land. It was not called for. So I don't think politically you might have different views. But legally, I do not think that on the facts and arguments before the court, of course, two views can be taken, but you are bound by a certain framework of a particular dispute. You are not handling this dispute about secularism. You are not handling a dispute about the destruction of a mosque. Have a criminal proceedings on, and there are still criminal proceedings which are guided by the Supreme Court. In fact, the Supreme Court has gone quite out of the way and required the magistrate to retire, a High Court judge, I think, will not retire till his services are extended by the end of the year by an order of Justice Dhananjay Chandrachud. So that proceedings are still going on. So criminal justice is not immediately involved. And the time-bound justice is ordered by the court, and the court is looking after that particular case. And the proceedings are nearly getting over. Now, whether as all criminal proceedings, whether the judgment is acceptable to parties concerned, they will go and appeal, that's a different matter. So this was only a property dispute, that you have to keep in mind. And if you disagree with the Supreme Court, then you should have good reasons, good appreciation, or a different appreciation of evidence of preemption, of adverse possession. That is the main thing. So my views are clear. I've given in the press. Outlook has carried it, the Express has carried my article. I've been attacked on this indirectly. People have been disappointed with what I've said. But as a citizen, I perform my duties. If there are fellow citizens who perform their duties and I ignore their views, I'll be grateful and I'll correct them if I am convinced, if they were to send it to me or bring it to my notice. To the best of my knowledge, nobody has argued on the substance of the matter as decided by the Supreme Court. Everybody has argued either by saying the mosque should not have been demolished. And I agree, as a Vice Chancellor of the Delhi University, I issued a public statement on the demolition of the mosque. I said it was a demolition of the Constitution. But right, switch on.
Generator.
I switch on my computer switch. Sorry, I lost my electricity provider. So I don't think, to wind up to this discussion, I have been on record that destruction of any public property, any religious property, is contrary to the law of the land and should be dealt with by the law of the land. And I think it is being dealt with. It should not take so long, but it's voluminous evidence and so on. That's a different matter. But it will be, as Gurudev Tagore, according to somebody else, I think, said once, the wheels of God grind very slowly, but they grind exceedingly fine. And I say the same about wheels of justice. They grind very slowly. Wheels of criminal justice, they grind very slowly, but they grind very fine. So, but that's as far as that goes. Anything else?
So, though there are many questions, if you want me to cherry pick, then I can do that.
Okay.
I just want to know if you have time.
Yeah, okay. Panel, 10 minutes or so. Yes, panel.
So should I take last question or last two questions, whatever you say, sir?
Yeah. What are the last questions?
So, though there's a huge list of questions, I just want to ask you, do you want me to cherry pick for you if you have the time for us, or take the last question?
Whatever you decide, I will. I'm your guest.
Okay, sir. So we would like you to answer all the questions. So if you stay, I'll just go and read all the questions to you.
No, Harpreet, we may ask last two questions.
Sure, sir. Sure.
Okay. Yeah, go ahead.
So there's one question which is asking about that what may be the role of CM in judicial appointments?
That's a very interesting question. That is, does CM apply to what I have called, I've divided judicial leadership into two wings. One is hermeneutic judicial leadership, when judges interpret the norms of law and announce their decision. Other is organizational leadership. A collegium, in my opinion, comes into organizational leadership. Very important. Who shall be appointed as a judge, elevated as a judge. Now, clearly, CM applies to hermeneutic judicial leadership. There is no question. It is relevant and it is compelling and binding, and it should be taken into account when you interpret the Constitution. Right? Whether it applies to administrative leadership or organizational leadership is a very important question as well. But the court's view has been, and I think the lawyer's view also has been, you might remember, I don't remember, yes, it happened in your time, very recent, last year, year before, there was a case of Assam Chief Minister, Mr. Pool, I think, who committed a suicide. And Mrs. Pool filed a petition before a letter to the Supreme Court. Justice Care ordered it to be heard on the merits in the judicial side. And Rustan Dare protested vehemently. He was the lawyer for Mrs. Pool, Durgambika or somebody. And he said, we never wanted this to be a judicial matter. We wanted it to be an administrative matter. Heard on the administrative side. What is the distinction? The distinction is that constitutional morality and basic structure and all the norms of constitutional law will apply when the court is exercising, in my words, hermeneutic adjudicating leadership. When the court is exercising its organizational judicial leadership. Take the second case of Justice the last Chief Justice and the complaints of sexual harassment against him. So they put back to a committee of administrative judges, 3 judges, Justice Bobde, 2 women judges, Justice Indra Banerjee and Justice Indu Malhotra, I think. So it is not judicial. Now the question is whether there could be a separate standard when you're acting in this capacity than when you're acting in that capacity. It's a very important question. But what you do in administrative cases, administrative leadership, is that you do not disclose to the public the grounds of the decision, because it is an administrative matter. Now that makes collegium probably unaccountable. If you look at the website of the Supreme Court, it simply says nothing about why they have selected a particular person over other. And the former Vice Chancellor of Delhi University, and Pradeep will himself tell you as a dean, if you look at universities, for one post, there are 100, let's say, 100 applicants duly qualified to appear for interview. You have to call them under the UGC norm. Now what happens, I don't know. The new education policy, where UGC itself is demolished. But somebody will be there. to prescribe the norms. Okay. Now, so we have to select only one person out of 99. They're equally meritorious. What reasons can you give publicly which will withstand scrutiny? So I founded a classification. One is progressive arbitrariness. Other is regressive arbitrariness. When you are progressively arbitrary, it means you apply maximum procedural fairness to all candidates, give them equal time, you do equal dignity accorded to every individual. So I sat in a committee for one person, 100 people, 150 people were duly qualified, then morning, evening for 8 days, 9 days, 10 days, and you selected one person. Obviously, less of 99 would say we are equally meritorious, and there is no way. So if there is regressive arbitrariness, if you give somebody 5 minutes and somebody half an hour, procedural lapses of those kind where you show your partiality is many court provincial justice oriented Nariman now calls manifest arbitrariness. That's regressive arbitrariness. Telltale that you didn't want X or Y. So I think you can avoid the administrative decisions also. You should avoid. And to that extent, CM would apply. You should avoid regressive arbitrariness in your decisions. It depends on case to case, which is regressive, which is not obvious. But it is your standard. So my answers are long, but it's hopefully not entirely thoughtless, and hopefully it will provoke some discussion.
Thank you, sir, for your answers for the questions that we were able to take in the short time. Though the list is long, but due to paucity of time, we were not able to take up all the questions. But sir, if you look at the chat box is filled with compliments for you. And it has been a great pleasure to have you and to get connected through this medium with you over this particular topic. Now I would like to formally thank you for gracing your important work and sharing with us your findings and opinions today. I must mention our deep sense of appreciation to Dean School of Law for encouraging us to organize this webinar. I thank my colleague Dr. Irfan Rasool for coordinating this discussion with me. And I would also like to take this opportunity to place on record our hearty thanks to Administration School of Law for providing us with the perfect logistic support and the guidance they have extended to all of us. Finally, I thank all the students and other participants who turned up in such great number. I thank all of you for your cordial cooperation.
Thank you very much.
Thank you.
We remain indebted to you, sir, and much obliged, sir.
Thank you. Thank you.
Thank you very much.